The Judiciary, Civil Law, and Public Safety Conference Committee will come back to order. Members, you have in front of you additional articles that are ready for consideration for adoption. We're going to start with Article 3, Judiciary Policy. I'm going to ask, do we have a designated staff person there? Pardon me?
I can do it.
Okay, we'll have Chair Becker-Finn give us an overview of what's in this article. Chair Becker-Finn.
All right. Thank you, Chair Latz. So I would move adoption of Article 3, which is the judiciary policy provisions. The first couple sections have to do with the statewide Office of Appellate Counsel, which, as folks saw this morning on our spreadsheet, that's actually the first many pages. Pages 1 through 9 is the State Board of Appellate Counsel. And then we've got 1 through 8. And then page 9, we also have the analyzing civil rights trends language. That was the Representative Vang, Senator Mohammed language, and that has been updated. Next, we have the disposition of fines and fees for Ramsey County suburban cities. That was Representative Curran, Senator Gustafson provision, also on the spreadsheet. And then we have the state public defender language, untying the state public defender salary with the salary of a district court judge, which was a Senate position, but that is what is in Article 3.
All right, thank you, Chair Becker-Finn. Is there any comment or discussion or questions from members of the conference committee? Senator Weston.
Thank you, Mr. Chair. As the Senate author, this is the statewide Office of Appellate Counsel and Training. It's really critical. We have situations where parents are literally potentially losing their children. They need representation, and this is a good provision to make sure that they have that access to qualified, competent legal counsel. And so I'm very proud to have carried this on the Senate side.
Any other members of the conference committee have any questions or comments?
Yep. Yeah.
Senator Westland, would you like to move adoption? Oh, I'm sorry. Chair Becker-Finn already moved adoption.
I did.
At her initial.
Yeah. But I can withdraw my motion, and Senator Westland can make the motion. That's fine with me.
Senator Westland.
You see how collaborative women are working with each other, I just want to say. But I so moved, Mr. Chair.
I think Representative Frazier and I have proven that we are somewhat collaborative, too, in this process.
Mr. Chair, we have had
Being the only male members of the conference committee.
We have had a very good influence on the two of you, I'm sure.
All right, well, I get the last word because I get to call for the vote. All those in favor of the motion to adopt Article 3, say aye.
Aye.
Opposed? Motion prevails. Article 3 is adopted. Before we go on, I'll just give a quick note about how we intend to proceed here. The House is reconvening at 3:30, so that's going to be our stop time for this portion of this conference committee. There is still work that is being prepared behind the scenes to get the articles ready for us to consider and put them in front of us. So we're going to get as much done as we can in the next 45 minutes or so. Whatever we don't get done now, we'll wait until we reconvene after the House is available again. But either way, we're going to have to be coming back, just so you can plan accordingly. Next in front of us is Article 19, which we considered this morning. We were waiting on an amendment that was being drafted relating to a report on supervision fees. Members, you should have the A86 amendment in front of you. Representative Feist, did you want to address this?
Thank you, Mr. Chair. I couldn't find it. Yes, I would move to adopt the A86 amendment to the Article 19. Oh, you want me to-
And did you want to explain it?
Yeah, it just adds a report on the collection of supervision fees by the counties to the Community Supervision Advisory Committee.
Perfect. Any questions or discussion from members of the committee on this? Not seeing any. Representative Feist, wish to move the amendment?
Yes, so moved, Mr. Chair.
Representative Feist moves adoption of the A86 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted.
Now the
Yeah, that was the A86. I'm sorry, let's redo this so we make sure we got the language right. Representative Feist now moves adoption of Article 19 as amended.
Yes, that is my motion.
All right. Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. The article is adopted as amended. One of these days, I'll get it right. I need more practice. Article 5. This is the general crimes article. We'd like to have staff go through it. Yeah.
I can talk to some, but
Yeah. Why don't we have staff go through what's in here? This is, contains a lot of different pieces in it. So, which staff would like to take that on? Mr. Backus?
Mr. Chair, members, yeah, I guess I could just walk through it. It has a number of provisions dealing with the surreptitious intrusion or the peeping Tom crime, which I believe were either identical or substantially similar in both bodies. Beginning on page 3, Section 2 is a house-only provision on the expansion of the qualified domestic violence-related offense definition. Then there is the language beginning on bottom of page 3 relating to the felony murder, and that also appears towards the back of the article, if you give me a second, as section 24 as well. There's 2 sections for that. There are then a number of provisions relating to the expansion of the various crimes relating to bias, adding additional language there. Those provisions were pretty much identical, if I remember correctly. There's, on page 5, the Senate's new carjacking crime is included. And also, instead of doing the separate article of conforming changes, which was something like 30 pages, we simply had the reviser do a reviser's instruction on page 27, if you want to look at that, section 25. So it saves quite a bit of paper there. Then there's, going back to page 6, there's the House provision tweaking I believe it's the kidnapping crime, separating those clauses so that there can be better reporting. There's next is Section 8, the provision relating to basically the exception for the crimes against unborn children. That's Section 8. Then there's a few provisions relating to organized retail theft. The most significant is on page 8, Section 10. This provision was rewritten by the Senate in committee and kind of rewritten again by staff to further tweak it, working off the Senate position. Continuing, page 11, there's 2 burglary changes. They were part of the organized retail theft bill initially. Those were identical. Continuing into page 12, there's a few provisions relating to criminal damage to property. That was part of the bias crime bill. And again, those were pretty much identical, if I remember. Page 14, there's 2 provisions relating to the machine gun crime. One, Section 15 was a house-only provision, expands the definition of what a trigger activator is, and then Section 16 expands, increases the penalty for machine gun possession. Continuing then, there's some surreptitious intrusion language, which again was identical. Page 17, Section 18, there was more of the bias crime language. Section 19 on page 18 is the Senate's swatting crime, which was a Senate-only provision, which is being adopted. Section 20 is a reworking of the concealing birth crime. I think that the Senate had that. The House had that in a separate bill in Ways and Means. And then continuing, Section 21 is basically a conforming change relating to a repealer that we'll get on later. Section 22 relates to the statute of limitations for the surreptitious intrusion crime. Then 23 on page 20 is the reviving the task force on aiding and abetting felony murder. I already mentioned Section 24. That is the felony murder provision, which allows people to seek relief for prior convictions in certain cases. And then that takes us to page 27. I mentioned the reviser's instruction already. And then the repealer is was more or less identical. It's sodomy, adultery, and then it also has some 617 provisions that the Senate brought into conference committee.
Thank you, Mr. Backus, and fornication also in the list of repealers. Chair Moller.
Thank you, Mr. Chair, and just wanted to highlight a couple of things. The surreptitious intrusion provisions passed unanimously off the House floor. It was a bill I carried, and Senator Gustafson had that in the other body. Also just wanted to point out some of the differences with the felony murder law reform that were in the Senate's bill and the House bill and how those differences were resolved. The Senate bill had expanded it to include people who had initially been charged with aiding and abetting felony murder, but who pled guilty to second-degree intentional murder. And in looking at how that would work, it just didn't work very well within the structure of this bill. So what we did was we took the bill back to the sort of the original aiding and abetting felony murder charges and convictions. And then you'll see when we get to one of the other articles that people that were in that situation with the initial charge of aiding and abetting felony murder, but a guilty plea to second-degree intentional, would have the right for clemency reform, and kind of created a separate factor that'll be considered for those folks. So you will see them when we get to the article related to clemency. Thank you, Mr. Chair.
Any other members of the conference committee wish to make any comments about this? I'm going to note the organized retail theft provisions. There have been occasions in the news where you have large-scale smash and grabs or other efforts to run into retail establishments, clearly well-planned and thought out and organized ahead of time. And you also have theft rings, which are sending people in ones or twos as an organized business, essentially, to steal from retailers and then transport the stolen property somewhere else. And so law enforcement came to us for the purpose of more clearly defining what this was, increasing the penalties, and giving the law enforcement the tools to investigate and charge out these particular offenses. So that's a substantial effort in which we are giving more tools to law enforcement to especially hold retailers in a better position. And the fact is, we all, in the prices for everything that we buy at a retailer, there is a part of it that pays for loss due to theft that the retailer has to cover as part of their operating expenses. So hopefully this will reduce that to some degree as well. All right. And I'm also pretty excited about the bias-related penalty enhancement provisions that are in here. It's been an ongoing process over many years. I carried and implemented and passed the first bias crime penalty enhancement provisions years ago now. And I think it's good that we're getting more explicit in how we address it, more open. We collect information on it and make sure property crimes are appropriately included, not just assaults. So it's especially in the last 4 or 5 years, they become more and more prevalent. And I hope this is taken as a strong message that as a civilized society, we are rejecting them opposing them and condemning them. And you will pay a higher price if you commit them. All right, any other comments or from members of the committee? Chair Moller.
Thank you, Mr. Chair. I will move adoption of Article 5.
Chair Moller moves adoption of Article 5. All those in favor say aye.
Aye.
Opposed? Motion prevails. Article 5 is adopted. Members, Article 8 on expungement. Who wants to walk through this one? What is- Counsel?
Mr. Chair, members, Ben Johnson with House Research. Article 8 deals with expungement. I'm not going to walk through section by section, but this bill contains 4 significant changes to expungement law. 2 of those came from Majority Leader Long's bill that's commonly referred to as the Clean Slate Act. That creates an automatic expungement process for certain offenses, and it also expands the list of offenses for which a petition expungement is allowed and slightly modifies some of the provisions related to petition expungement. There were no changes between what passed the House and also passed the Senate and went into this bill except for some small technical clarifying changes to match it up with the other provisions. The other provisions were Representative Frazier carried them in the House. One of them dealt with pardons, creating automatic expungements in relation to pardons, and the other dealt with mistaken identity, creating automatic expungements in cases where someone was arrested or charged as the result of mistaken identity. You'll see that a few of the sections related to the pardons have been moved from here into the next article that we're going to talk about, which is the clemency reform article. That's because the clemency reform article changes and repeals many of the statutes that were amended in the expungement article. So those provisions remain part of the overall bill. They've just moved a little bit so that they're conformed to the other changes we're going to be presumably adopting in Article 9. That's the high-level overview of what's in Article 8.
Thank you, Counsel. Any questions or comments from members of the committee? Representative Frazier, would you like to move adoption?
So moved, Mr. Chair.
Representative Frazier moves adoption of Article 8. Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. Article 8 is adopted. Members, Article 9 is now before us. Clemency reform. Mr. Johnson, is this one for you again? Or Mr. Diebel? Or Mr. Backus? We're all kind of looking at each other. No, you take it. No, you take it. Let's get Mikey. Only a few of us even remember that ad. A cereal ad. All right. Sorry, not all of you are old enough to have seen that growing up. All right. Mr. Johnson.
Mr. Chair, members, Ben Johnson again with House Research. This is a change to the current clemency provisions. Again, at a high level, right now we have a pardon board in the state of Minnesota. This makes a change to the way the voting in the pardon board works. This passed both the House and the Senate. Right now, it requires a unanimous vote of all 3 members, which are the governor, the attorney general, and the chief justice. This would modify it so it's a majority vote, but the majority vote must always include the governor. So the governor and the attorney general, or the governor and the chief justice, or obviously a unanimous decision could result in a pardon. This bill also creates a new clemency review commission. That's essentially a new entity to screen clemency applications. It also makes a variety of clarifying and technical changes related to the existence of this Clemency Review Commission, their scope of work, how applications are made, what they're supposed to consider in making their recommendations, and the process for them to make recommendations, and then the pardon board to act on those recommendations. As I mentioned in relation to the previous article, this particular article will now also include some of the provisions related to automatic expungement for the records after someone receives a pardon. That was in the expungement-related provisions earlier. They've been moved over here again just to merge those up because of the changes in this part. Finally, there are some changes related to the felony murder provisions that were adopted earlier as part of Article 5. This is a change that allows certain individuals who are charged with second-degree intentional murder, convicted, or pled guilty, rather, it's a little complicated, pled guilty to second-degree intentional murder after being charged with other offenses. They're authorized to petition for a pardon immediately upon the completion of their sentence instead of waiting 5 years under certain circumstances. Again, that completes the high-level overview of this article.
Any questions or comments from members of the conference committee on clemency reform? Senator Umover Baden, would you like to move adoption of Article 9?
Yes, Mr. Chair. So moved.
Senator Umover Baden moves adoption of Article 9. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Opposed? Motion prevails. Article 9 is adopted. Article 10, members, evidence gathering and reporting.
Mr. Chair.
Mr. Diebel.
Mr. Chair and members, Article 10, the proposed conference committee version, it contains 4 proposals. The first 4 sections, along with Section 8, are the financial data provisions, which were in both House and Senate. The second significant piece in this is the no-knock warrant reform. The third piece, which jumps to the carjacking report on page 6, again, which is in both provisions. Both bodies had that. And then the final was an identical provision on mobile tracking devices and the use for automobiles. And that's on the final page.
Do any members of the committee have any questions or comments they'd like to make regarding Article 10? I think I'm going to note that the no-knock warrant provision in here was a subject of a lot of stakeholder input and committee input along the way here as a product of a lot of analysis and work in our we think is our best judgment to substantially restrict the availability of no-knock warrants, but to leave it available in the limited circumstances where a judge and the law enforcement agency think it is the best tool to use to protect officer safety and the safety of those who may also be involved in receiving the warrant. I will also note then also, and Chair Moller and I have worked on this for a while, on tracking devices. This is one that did not make it across the finish line last year. It was the subject of some substantial differences between House and Senate, and I'm glad that we were able to find a way to move forward here with a more limited approach to see how well these tracking devices will work in real-life circumstances, and that may become a platform for evaluating use in the future as well. Is there any further discussion on Article 10? Representative Curran.
Thank you, Chair. And quickly, yes, just wanted to thank the committee and stakeholders for all the hard work. I know on a lot of components of this, but I'll specifically mention, speak to the no-knock ban provision. Just really appreciate how everyone's come together, worked on this language to come to an agreement, and really proud to get this done this session. So thank you so much.
Anyone else? Representative Curran, would you like to move adoption of Article 10?
Yes, Chair. Thank you. So moved.
Representative Curran moves adoption of Article 10. All those in favor say aye. Aye. Opposed? Motion prevails. Article 10 is adopted. Article 11, Policing and Private Security. Mr. Diebel.
Mr. Chair and members, I'll again identify the proposals that are contained in this article. The article starts with language on body cameras in Chapter 13, and it also contains a position on the model policy that agencies that use body cameras must employ. So the three provisions are a combination of the House and Senate position on that proposal. The Article 11 also contains provisions regarding post-investigations and compliance with the agencies. There are also the private security regulation reforms that were both some came from the House and some came from both the House and the Senate. The portability issue of qualifications for those who are trained to be security agents, excuse me, is contained, along with the House's position regarding the proposals to strengthen the private security board's oversight authority. Also in this article is the House's position on reforming the definition or standard for peace officers' use of deadly force. The provision on bias crimes is, the provisions on bias crime that were in both House and Senate provisions are in this article. Also, the House's position on the ban on peace officers associated with hate groups, both those provisions are in this article. The no retaliation for reporting misconduct provisions from the Senate are in this article. The requirement that agencies cooperate with Post Board on investigation of officers, those provisions are in here. The Peace Officer Training Program is in here with modifications that were coordinated with the stakeholder groups. That's the intensive Peace Officer Training Program. Peace Officer background checks provisions are in here. Those were identical in both bodies. There is a modified version of the civilian oversight provision that the House brought to Conference Committee that's contained in this article. The provision on Minneapolis Police Department's session law staffing obligations that the Senate brought to Conference Committee is in this report. And then finally, the provision on tribal law enforcement that's contained in this article but was adopted yesterday by the committee. So that concludes the overview of Article 11, Mr. Chair.
Thank you, Mr. Diebel. Any questions, comments, discussion from members of the Conference Committee? I would like to highlight a couple of provisions here. One is with regard to the use of deadly force. I'm glad that we had a chance to take a look back at that and update that a bit, provide some additional guidance to law enforcement and when it's appropriate and how to go about that. I'm very pleased that there's a prohibition for peace officers to be affiliated with hate or extremist groups. Extraordinarily important for the community to trust their law enforcement officers, not only as they are actively enforcing the laws, but also as they are investigating criminal conduct, that they are not dealing with an arm of the state that has an active bias against them because of their membership in any particular protected class, ethnic group, or gender identity, or anything like that. So this should build confidence, and unfortunately, we saw that this is a real concern with information that came out after January 6th about some of who participated in that. There's active efforts, enhanced efforts here to train law enforcement to recognize crimes motivated by bias. And also, I think, very importantly, as we saw coming out of the George Floyd murder, the importance of protecting police officers who choose to report on their own colleagues when they believe that important prohibitions or guidelines about their conduct are being violated. In this case, improper use of force in the case of George Floyd. But we heard repeatedly in the media that some members of that group, of the law enforcement that was there, were inhibited from calling out the main perpetrator because he was a training officer and had years of experience, and they were afraid of retaliation either by him or other members of the force or the institution. And so we're doing what we can to make clear that they are prohibited from retaliation, but most importantly is going to be how this is employed and enforced on the street in law enforcement agencies. So all we can do is put some words on a page here, but to make it active and real, individual agencies and individual officers are going to have to take those steps on the street to do that. And we give a better ability for the post board and for agencies that are hiring officers to know the backgrounds of the officers they're contemplating hiring, so that officers that have a checkered background or have had trouble in one agency can't just quit there and go to another agency without their history following them, or at least the new agency can make a factual determination whether they want to go ahead and hire that officer. So to me, that's another very important piece of this. And then there are a very intentional effort here to improve peace officer education and training. You know, lawyers have 45 hours of continuing legal education that we have to comply with every 3 years, and when we make mistakes, you know, someone loses money usually, or in some cases, perhaps worse than that. But when an officer isn't properly trained, they make mistakes on the street, literally lives are at stake, or can be. So to the extent that we can, and we see it especially with regard to people who have mental health issues and are causing disturbances, and the call goes to 911. So this is, I think this training is also a very important component. And then we also provide some guidelines for civilian oversight councils as well, which will give communities more authority and ability to do civilian oversight councils, and then refers follow-up in appropriate cases to the post board as well, to provide a little more distance and objectivity when there's community pressure over any particular incident as well. So hopefully we struck the right balance with that. And I know that Chair Becker-Finn took a particular interest in making sure that tribal agencies had appropriate concurrent jurisdictions and for cooperative agreements, and those provisions are here as well. I want to note one other little piece that is not hugely significant, but sometimes you just find things as you're working on bills. The Minneapolis police chief came to me asking for some authority to be able to organize the new department in the way that he thought was most appropriate to make the changes that he thinks need to be made there. And found that there was a statute that, literally the statute specified the number of deputy chiefs and inspectors that the department could have in Minneapolis. And it certainly did not make any sense to me that there ought to be a legislative statute specifying how that city ought to be able to organize its own police department. So this bill deletes the numerical references in there, but in the course of reading that one paragraph in statute, I noticed that, and you'll see this on line 24.17 of Article 11, the last word in that sentence made a reference to the rank of patrolman, which was clearly an antiquated term that had just never been updated since 1936 or however old the statute was. Maybe probably more recent than that. So we caught that and changed it to patrol officer, as it should have been from the beginning and will now be forevermore. So with that, is there anyone in particular who would like to move adoption of Article 11? Representative. Of course. Chair Moller.
Yeah. Thank you, Mr. Chair. And just wanted to point out again that intensive comprehensive peace officer education training program that begins on page 16. Thank you, Senator Seeberger. That was your bill with Representative Hewitt. And when we talked to law enforcement groups at the beginning of session, throughout session, officer recruitment was and remains, I think, one of their number one issues. And just wanted to thank you for your work on this bill. I think it's a really important bill, and I'm glad we could include it in the finished product. Thank you.
Senator Seeberger, would you like to take some credit for the work that you did on helping to enhance the law enforcement workforce on a more expedited manner?
I will absolutely take the credit for that. Thank you, Mr. Chair. You know, I heard the same things, and we do have a recruitment and retention issue when it comes to law enforcement, and I'm glad, and I was really happy to work with Representative Hewitt on this and come to, I think, what is pretty good language that will certainly help our police departments and law enforcement departments across the state. So thanks for pointing that out.
Any further discussion? Senator Seeberger, would you like to move adoption of Article 11?
So moved.
Senator Seeberger moves adoption of Article 11. All those in favor say aye.
Aye.
Opposed? Motion prevails. Article 11 is adopted. Members, Article 14, or actually what is coded as the 823-0161 document in your packets. Firearms background checks. Mr. Diebel.
Mr. Chair and members, the position before the committee today is the version of this bill that passed out of the Senate committee. It has a few minor differences from the House. The first is really a drafting decision to expand the definition, or not the definition, but the references in the chapters to firearm from pistol, from semi-automatic military assault weapon, just to clarify. In the House side, that was to clarify that if you're ineligible to possess those type of firearms, you're ineligible to possess any firearm. But the House has accepted the Senate position, which does not address that issue. The House Senate position also does not, or the position that's before the committee does not accept the House's position to eliminate transferee permits as a valid method for proving your eligibility in record of transfer and report of transfer transactions. The other difference in the proposal is the penalty provision for failure to provide the report of transfer under the private transaction. That's the House position was a gross misdemeanor, and there'll be a misdemeanor under the adopted proposal. And I believe that addresses the, oh, and then one other key difference, Mr. Chair, that the retention period, the House brought in a 20-year retention period for the record of transfer document that would be required in private transactions for pistols and SAM saws, and has accepted the Senate's position of a 10-year retention period. That identifies the differences between the proposal the House brought in and the Senate's position that came out of committee, and that is before the conference committee today, Mr. Chair.
Thank you, Mr. Diebel. Any comments from members of the conference committee?
Oh, I'm just smiling.
Okay.
Sorry.
Senator Westland.
A clarifying question. So we are essentially adopting the Senate file except for the changes noted. Is that correct?
Mr. Diebel.
Mr. Chair and members, we are accepting the Senate position. I was just identifying the difference between the Senate position and the House. So I was describing the Senate bill in the negative to what the House brought to the conference committee.
So this is adopting the bill as it came through the Senate.
Thank you, Mr. Chair.
Senator Westland.
This has been a long time coming. I know that I have been getting communications on a very regular basis with people just begging us to do this. And I am so proud that this legislature is finally getting this done. And getting this done, along with the other one we're going to hear, in the face of ongoing, continued gun violence every single day at malls, at places of worship. It puts our law enforcement officers at risk, and we have recently lost beloved law enforcement officers. This is a long time coming. It should have been done a long time ago. And Senator Latz, in particular, I want to thank you because you have been fighting this battle, rolling this rock uphill for so long. And I am so deeply proud that we finally have the ability to create a safer community for our state, for the people in our state. And this will be a day that I will remember for years.
Thank you. As the chief author of the bill that is now incorporated here, I appreciate your remarks, and I've been working on this for at least a decade. And Senator Westland, I know you have been working on this long before you came to the legislature. It's been a labor of personal dedication for you, so thank you for your work on that as well. Senator Pappas has been a longtime advocate as well. We have worked together in the legislature to try to advance this initiative. So, any further comments from members of the committee? Chair Moller.
Well, since we're giving shout outs, I'll give a shout out to Representative Pinto. This was his bill, and he's worked really hard on these issues over the years too, not on our conference committee, but a member of the public safety team, and like I said, has worked really hard on that. So just wanted to give him a specific shout out. Thank you.
Thank you for that, Chair Moller, and I've worked closely with Representative Pinto over the years, trying to find the sweet spot in the votes. I think we may have done it this year. So with that said, Senator Westland, would you like to move adoption of the 23-0161 document in front of us?
I would be honored to move that, Mr. Chair.
Senator Westland moves adoption of the A23-0161 document. All those in favor say aye. Aye. Opposed? Motion prevails. The document is adopted. Members, we now have before us the A23-0155 amendment, entitled Article 15, Extreme Risk Protection Orders. Mr. Diebel.
Thank you, Mr. Chair and members. Again, I'll identify the slight differences between the proposal before the committee and the position that the House brought to the conference committee. The language in the proposed amendment is the Senate version of this proposal that came out of committee with one difference. I'll note that at the end. But the differences between the Senate position and the House are that the House, there's information that the bill directs the court to consider when evaluating the merits of a petition under this proposal. The Senate makes a slight modification, and in the House, we said any felony was relevant information, and the Senate has modified that with violent felony. The Senate permits respondents, those who have an ERPO imposed on them by the court, to appeal or have it reconsidered every 6 months, where the House's position was every 12 months. The Senate makes some significant changes to how the House had the language regarding law enforcement's processing and of firearms that were turned over by respondents or to an ERP order. The language before the conference committee requires law enforcement to prevents them from charging a storage fee, and it requires them to compensate petitioner respondents who forfeit their firearms to law enforcement. The final difference, as I alluded to earlier, is that this proposal contains a House-only provision which designates the Department of Public Safety as the state agency that would be eligible or responsible for applying for ERPO grants, and those would be available for storage grants and other implementation costs for law enforcement and state agencies. That concludes the overview of Article 15, Mr. Chair.
Any discussion or comments from members of the conference committee? Representative Frazier.
Thank you, Mr. Chair. I may echo what some of my colleagues have said. This has been a long time coming. We have gone decades, and we've only seen gun violence increase in our communities, in our states, around the country. And particularly, we've seen the gun violence increase in places where we send our young people on a daily basis, day in and day out. And in conversations I've had with parents, and particularly in my community and around this state, the fear that they have that when they put their little one on that bus in the morning or drop them off in that drop-off line in the morning and watch them go to that door, that they could possibly get a call saying that there's an active shooter and that they may not have that young one come back that night, is a fear that is real. And I believe putting this bill in place and hopefully getting it across the finish line as close as we are, we will now provide a tool to law enforcement that can be preventative as opposed to the reactive manner that we've been in so far. And the reactive manner that we've been in so far is we have active shooter drills. We're training our kids. We've normalized this violence that we have in our community. But this is a tool that can be preventative. And I know some of the opponents have said, will this stop and end all gun violence? It will not. But it is a tool that can prevent, and it is a tool that, if it saves 10 lives, if it saves one life, we have done a job that needs to be done. And I am very happy to move this bill today.
Any further discussion? Senator Westland.
Thank you, Mr. Chair. This, again, is another bill that is near and dear to my heart. My best friend died by suicide in 1991. We know from the research that the Violence Project has done, and I'm thrilled to know that we are providing them some additional funding for additional research. We know that very frequently those who engage in mass shootings are actually people who are experiencing a suicidal episode, and the mass shooting is a part of that. We know from the research that's been done that in a majority of the cases, there has been advance warning, sometimes for years, sometimes for weeks and months, but there's generally advance warning that someone is in crisis. This is not something that someone wakes up on a day, typically speaking, and that they then engage in an active mass shooting or engaging in an act of taking their own life. The signs and symptoms are there. They typically leak their plans to other people. People know that someone is in crisis. And extreme risk protection orders strike a balance between the rights of an individual to lawfully possess a firearm and our desire to keep that person safe, as well as the surrounding community and others when that person represents a risk to themselves and to others. There is no, as Representative Frazier said, we have never, ever, those of us who have been arguing for years about gun safety measures, no one has ever said any one of these provisions will completely eliminate gun violence and gun deaths and gun injuries. No one has ever made that statement. But this is about harm reduction. It is about risk reduction. It is about acknowledging and intervening and helping people before something happens. And so, again, it is so incredibly important that we are finally at this place where we are able to pass this law. And I do want to thank Senator Seeberger in particular, who I know worked with Senator Latz to create this bill and had input to make this the best bill that we could do. So thank you.
And as the chief author of this bill as well, and so for many, many years, I really appreciated Senator Seeberger's fresh look at the language and very helpful suggestions for improving the bill that we have before us today. You know, Representative Frazier, you mentioned active shooter drills. Well, we're training our kids at the same time we are traumatizing our kids. Well, I don't see that changing anytime soon. We do need to take active measures to prevent, or at least reduce, the risk that they're going to face a real-life situation. You know, this bill is important both for suicide and for homicide prevention. In Greater Minnesota, 60% of the firearm deaths are by suicide, not homicide. And there are warning signs or red flags in almost every case. Their family members see it, their close friends see it, sometimes law enforcement sees it, but we have created multiple paths toward a judicial consideration of an order, of a red flag order here, extreme risk protection order, so that it's not entirely reliant upon one path to the courthouse. We are, well, I don't know, as of yesterday, I think there were 199 mass shootings in the United States so far this year alone. We might be over 200, for all I know, by today. And unfortunately, it seems that in some states, the governors are only willing or interested in pursuing red flag laws after there's been a mass shooting in their community, in their home, in some cases, killing friends of their or family members. Hopefully, well, now we will not be waiting for that kind of a tragedy to happen in Minnesota. We have had a few mass shootings in Minnesota, and fortunately nothing recently, but we're going to take some proactive steps here to do everything we can to prevent that as well. And the last point I'm going to make here is that one of the arguments that have been made against both of these gun bills is that the guns aren't the problem, it's the people. Neither of these bills ban firearms. These bills focus on the people, separating the firearms from the people who are, under existing law, ineligible to possess firearms and therefore shouldn't have them, or people, because of a crisis that they're in, are an immediate threat to the safety of themselves or their family or others around them. These bills focus on the people. And I think this ought to be a very effective approach, and the evidence shows in states that have them that they do have fewer incidents of gun violence. Chair Beckerfin?
Thank you, Chair. And I do want to, so I don't forget, Chair Moller, I don't know that you would have run for office, but for fighting for some of these things. And I know that's something that you have put, she works hard on every bill if you've worked with her on anything, but especially on this. I know the dedication to get to this point. Both of these pieces are reasonable, necessary, impactful provisions that will save lives. And I say this as someone who had a shooting in my neighborhood in the last year where we had a Roseville officer who was shot. He survived and is okay, but that was a person who should not have had access to a gun. And there were many people who knew that that was a person who should not have had access to a gun. You know, I was in the position as a gun owner. I knew that what I was hearing was gunshots and not fireworks. A lot of my neighbors who are not familiar with firearms didn't realize it. And I was the one that was like texting everybody, telling them to get to the basement as we didn't know what was happening. You know, 100 bullets in our neighborhood. And I also sit here today as we're about to pass this, very top of mind for me. We had I did not know him personally, but we had a very beloved community member and hockey coach in with Roseville Youth Hockey in our area who, he was the one who interrupted somebody breaking into a vehicle in the last week and was shot and killed. And I have no doubt had those people not had firearms, he would still be with us. And I think to the point that many of us have made, like, what cost is enough? Because that trauma is reverberating across my entire community right now. The loss of that one person. It's not just about the one person. There are impacts on his children and his family and everybody in the entire community, even those of us who didn't know him personally. And so I think that's why this is really important, I think, to me, and I think a lot of us, is that it's, we look at all these numbers and they're like statistics and like legal talk, and what the reality is that they're real people's lives who are destroyed by gun violence. And so I'm just really proud to be part of this, and glad we're moving this forward. And I will also say that these can't be the only things we do. That these conversations need to continue, and there are other things that we need to do kind of across the board. And I know we're all on this committee, this conference committee, all of us here dedicated to that. And so look forward to the continued work, but this is a good day, and really happy that we get to move this forward today. Thank you.
Chair Moller.
Thank you, Mr. Chair. And I just wanted to thank Chair Becker-Finn, too, because of her expertise as a hunter and as a gun owner. Really has been invaluable as we work through this legislation and others. And then I just wanted to take us back to Rachel. I think many of you know Rachel, whose Aunt Shelley was murdered by somebody who got a gun at a private sale, had a number of red flags in her own background, and she was yet able to get a gun, and she shot Rachel's Aunt Shelley, the Hennepin County Government Center, and somebody else. And so I just want to lift that up. I want to lift up Rachel and Shelley and all of the victims who have been fighting for this legislation for years and years before we even started talking about it, and just want to remember them as we vote to advance this bill today. Thank you, Mr. Chair.
I knew Shelley's family very well personally. That was hard. Representative Frazier, would you like to move a 23-0155 amendment?
Yes, I will, Mr. Chair. So moved.
Representative Frazier moves adoption of the 823-0155 amendment to the conference committee report. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Members, that's all the work that we have ready to do right now. We are going to recess to the call of the chair, and you will get notice when we are prepared to come back and hopefully complete our work.
Nice.
Sometime,
Don't go home.
as soon as the work is ready, Senate Judiciary Committee is going back into session in 20 minutes. So it will not be within the next hour, I expect.
Yep.
Maybe that's a nice way to say it. But watch your postings, and we'll be back at some time yet today. We are in recess to the call of the chair.